Mr. Chair, respectfully, since we're at this point where the representatives can voice out their concerns, I appreciate the good intention of the bill, first. Second, I do see the value of diversifying energy sources, but I have some legal qualms with the bill, and it relates to fairness. First, the bill makes factual assumptions, and the factual assumptions is a technical issue that nuclear is cleaner, cheaper, and safer. In the absence of a technical person or expert, I'm grappling with that issue, whether in fact the assumptions are correct. Second, it also makes the assumption that the BNPP is ready to run. I do note that it's brand new, but it is decommissioned. It has been decommissioned for 40 years. Whether that impacts the safety or efficiency of the plant is a question. If there are nuclear engineers present, I think it's time for them to chime in. And so, unless these factual assumptions are addressed, we are risking violation of the Equal Protection Clause. The whole point of EPIRA is really to promote competition, to get government out of it. And the bill proposes that the government may or can take over running nuclear facilities. And it's very hard to compete against government. That is my fundamental issue with respect to equal protection. Equal protection allows valid classifications. And valid classifications should be based on substantial distinctions. And in this case, it's really the superiority or supposed superiority of nuclear energy. So until that factual assumption is made, right, then how do we justify incentives above and beyond EPIRA? So that is my first concern. Second, with respect to the social license, I'm not aware, I wasn't in Congress when you had that supposed agreement with Congressman Abet. But this much I know, I see a double standard in this bill. In that for new nuclear facilities, the bill requires a social license. But for Bataan, we were not given an opportunity, sir. With all due respect. The only way you can justify a special treatment is that the activity is special. You have to prove that there's a substantial advantage that can only be established in the committee through experts. Second, with respect to equal protection, if you are requiring as a social license for new nuclear facilities, then you should as well require a social license from Bataan. My other concern relates to due process. Due process under the Constitution is deprivation of life, liberty, and property without being heard or given an opportunity to participate. In this forum, the absence of other industry players is notable. We don't have representatives from the renewable energy sector, fossil fuel, coal, and other industry players. Third due process concern relates to the clause in the bill regarding judicial relief. Here, it is limited to the Supreme Court. I have practiced law for a long time, but it is tantamount to basically preventing judicial access. Because it's hard to file cases in the Supreme Court. It's a very tall order. It is expensive. It is a highly specialized practice. And therefore, I don't see why it should be limited to the Supreme Court. I have other issues concerning capacity of government to run this. By nature, I've always believed in the private sector. My background is in economics. I do believe in government participation, but only to level the playing field. And the last concern is, I note, Mr. Chair, that there is no appropriations clause in the bill. When I said there's no appropriation clause, there's no clause designated as an appropriations clause, because usually in bill drafting, as I've been taught, is that usually there has to be an appropriations clause. Yun lang naman po binabanggit ko, but there are funding sources, then there are funding sources. That's all I pointed out. With respect to the social license po, we have to look at the spirit behind the social license. It's really consultative in nature and to get the community consent. We cannot infer community consent from the election of the president, whom I fully support. In fact, my father was a member of KBL for the longest time. But, at bottom here is that why are we requiring social licenses for new facilities and not for the old decommissioned nuclear facility? We have the Sangguniang Bayan resolution from Morong effectively opposing the resurrection and the operation of the nuclear plant. This is something we need to grapple with. And as well as when I was a board member, there was a Sangguniang Lalawigan ordinance opposing the operation of the Bataan Nuclear Power Plant. These are facts. I don't want to be caught in a discussion about politics of that. Is that sufficient community consent? or not. The way what the bill envisions is communicable consent confirmed through the COMELEC. Is the sponsor willing to have a COMELEC plebiscite in Bataan to confirm their sentiments with respect to the operation of Bataan Nuclear Power Plant?